Any mention?
Please, Your Lordship. In item number 25 to 31, those land acquisition matters, my Lord, I had submitted on the last date on only 4 points, and I had expressed that I wanted to continue on certain other points. So I've realized, my Lord, those are better suited as replies to my learned senior's cross appeal. So I'll close for now. I've already communicated to my learned senior, he can start.
Lordship, if I can be accommodated on Friday, I'll be highly obliged, Your Lordship, because if he's closing, I also, 4 points are there. I will meet it on Monday if Your Lordship can accommodate us on Friday.
Friday is 31st?
31st.
We'll post it next week, Mr. General. Friday is rush day.
Friday,
This will possibly require 2 more days of hearing.
Yes, I mean, actually what we ideally can do is that we post it on 2 consecutive days so we can complete everything.
Yes,
so
that can be done.
The matter's been pending for a long time. You give 2 dates, any date of your choice, Mr. General.
6 and 7.
6 and 7, so it is, yes.
6 and 7 June.
That again, you're looking at another Friday. You can't have it midweek.
In between, Your Lordship, I'll be...
5 and 6.
All right, 5 and 6.
Either 5 and 6, 12 and 13.
Yes.
Take your pick. 5 and 6 or 12 and 13.
Okay. 5th and 6th.
Okay, 5th and 6th. On
He
the
is
prayer,
closing.
on the prayer of the councils for the parties, there's these matters on 5th.
Lordship.
Lordship, his submission is that he is closing.
So closing, that's what I'm saying. That doesn't need to be recorded.
Submissions of the lawyers, sometimes they say
Yes.
closing, you raise something and he
Lordship,
starts,
exactly.
he will jump up and start saying something. Yes.
Obliged, Your Lord.
My Lord may allow us to move one unlisted motion. It's the election of Village Employment Council on
Tomorrow?
4th. Today, my Lord. Tomorrow will be election. What happened, my Lord, on 4th of 7th of this month, Lordship directed one of the petition to the BDO on 7th of this month.
Yes.
Lordship has directed the BDO to conduct a VEC election. Accordingly, on 14th, the BDO has issued notification for verification of the job card holders. On 17th, they came for verifications in the village. Verification done already. And the team said that they will notify the final list of the job card holders to conduct election. Now, what happened before finalizing the job cards on 21st of this month, last week, they issued notification fixing 27th of this month as a date of filing nomination, and tomorrow is a date of election. Now, day before yesterday, the party has filed a nomination paper and inquired the final list of the job card holders so that they can conduct the election. Now the officers are telling that no, after the election is over, we will publish the final list of job card holders. Now in the job card holder, 406 job card holders are in this particular village. They came and identified some are dead already, some are having double job card holders, some are bogus. So they came and identified this one. Now retention of these existing job cards, they are going to conduct election tomorrow. So, my Lord,
how can we stop the process? It's already tomorrow.
My Lord,
now it's already been filed.
Now, if an election takes place tomorrow,
you file it after,
they will utilize all those
If suppose
bogus.
a successful election, will you challenge it? Will you say that the election is vitiated for inclusion of invalid job card voters?
Yes, my Lord.
You say that. Suppose you have put in a candidature, correct?
Yes, yes, yes.
Suppose you're successful tomorrow.
Yes.
Will you come with a petition to say the election should be set aside?
Yes, yes. If
You
Lordship,
will do that.
My Lord, if Lordship allow me to move today.
No, no. Suppose I don't allow you to move, right? And then election goes on.
Yes.
And you are successful.
Yes.
Will you come tomorrow and say, I'm successful, but I'm sorry, the job card, that list was wrong, so my election should be set aside and fresh election should be held?
My Lord,
will that be your submission at that point of time?
My Lord, since he raised this issue before the authority, definitely, my Lord, his stand will
That
be
means that
remain
you
the
have
same.
no chance of winning.
No, my Lord. My concern is, my Lord, they are bogus job card holders.
No, we won't
and
say
second,
it.
my Lord, second point, my Lord, in the notification they say that those who are a job card holders,
Will allow you to move it, but
I will satisfy, my Lord.
Yes.
I'll satisfy, my Lord. Today. Highly obliged.
see, Mr. Chair, suppose you win, you won't come and challenge it.
I'll satisfy, my Lord.
Your client will hide in the jungle. He won't try to contact you also. Yes.
Please,
Yes.
Your Lordship, I beg to mention item 35 and 36.
Item?
35 and 36, Your Lordship.
35.
Yes, Your Lordship. Kindly pray for 2 weeks' time. I pray for 2 weeks.
35
And
36.
and
And 36. Connected matter.
Jubaraj Boro.
Yes, Your Lordship.
Well, no objection. I pay for the seat. MPS.
2 weeks.
2 weeks' time.
Responded.
Okay, 2 weeks, yes.
Deeply obliged, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 37.
I have objection, Your Lordship.
Your Lordship, because my senior is having urgent matter and
Who?
Maukurwat Adjournment Cloud. So if it maybe comes after 2 days, Your Lordship.
Objection, his objection, so we'll have to hear it. What personal difficulties does he have?
That he did that.
With the other lawyers are there. Who's other lawyers with him?
They are not here, Your Lordship.
HW Dakhar is whom?
Adjournment Cloud is my senior.
HW Dakhar?
HW, no, they are not from our chamber.
Who's KK Khongjo?
No, they are from
They
the
were
other
the-
respondent, Your Lordship. I'm for the respondent number 1.
Only HW alone.
Adjournment Cloud, me and my colleagues, but they are not present today.
What's the matter about?
There were 2 suits, Your Lordship. The former suit have
yes,
succeeded,
yes.
and they have instituted a fresh suit now.
If it
So
comes,
ticket next week is a fixed matter.
Yes, Your Lordship. Yes.
Yes.
Positive.
Though what is your name? Sorry.
H. Carlor, Your Lordship.
Yes.
H. Carlor,
Oh, HK. Yes, you're
Yes.
here. You can't argue the matter.
Your Lordship, I can.
You can.
I cannot.
I
But my
can't. I
senior-
couldn't hear. I can't. I heard I
I
can. Yes. Ms. H. Karlor has sought adjournment on behalf of her senior, who stated to be unavailable due to personal difficulty. Stop. Next para Mr. Sarlingdo, Learned Counsel Petitioner has raised strong objections to the prayer for adjournment. Stop. Next paragraph. As Mr. Nofal is available in the interest of justice, matter stands adjourned for today. Listed on so and so is a fixed item. Next week, yes.
Obliged, Your
Very
Lordship.
obliged.
Yes.
Your Lordship, on joint request, item note 33 and 34, if this matter may be listed after 2 weeks, Your Lordship.
On June the 12th,
33 and 34, on joint request.
what are you submitting just now?
On joint request, this item
On
note...
joint request?
Yes.
I heard on June the 12th. Something wrong with my ears, I think. After 1 week.
After 2 weeks, Your Lordship.
Why?
Need to prepare a little bit here. I have to do some little research also at the same time, yes.
What's the matter about?
It's a little home guard. That is Mr. Sheikh has argued.
Who's the lawyer being here? Mr. Saikia?
Sheikh.
Oh, regarding, yes.
Yes, Your
Yes,
Lordship.
why? What is the problem? That is regarding that fifth pay commission.
Yes, the FIFA Commission. I need to do little research, Your Lordship.
Okay, 2 weeks.
I'll oblige, Your Lordship.
Yes.
Please, Your Lordship. Lordship, I beg to mention item number 8. Pray for 2 weeks' time, Your Lordship.
Number?
8.
Number what?
8, Your Lordship.
It's in the Afruza Khatun.
Lordship.
What's the matter about?
Regarding salary, Your Lordship.
Withheld, Lordship.
With your salary withheld.
Yes, Your Lordship.
You're not bothered with that. So after when? 3 weeks? 4 weeks take. That your clients apply. 3 weeks, yes.
Oblige.
Your client suffering, your yes. No.
Supplementary list, item number 1.
My Lord, this matter pertains to promotion.
Yes.
The promotion of the petitioner, my Lord, was due in January 2024 to the rank of Naib Subedar. In Assam, my Lord, they are following a policy which obviously has been found out to be wrong. They say that, my Lord, if you are serving an extra regimental duty, in that case, your ACR for that particular period would not be counted. So whoever is posted on an extra regimental duty within the Assam Rifles itself, my lord, their promotions get moved up.
Where's the stipulation?
In Annexer 6, Lordship, in a similar situation, this Honorable Court had already interfered in the matter, saying that since extra regimental duty is also part of Assam Rifle duty, your ACRs cannot be ignored for that particular period. And in Annexer 7 also, my lord, Annexer 6,
Is this extra regimental duty considered deputation? Oh, he's got lost. Where's Dr. Muzika?
He's on next, Lordship.
Yes, he's gone into oblivion. Yes, after some time. Yes.
Daily list, item number 1.
Second motion by item number 1. Same lawyer. We take 1 and 2 after some time.
Item number 1, daily list.
Number 1.
Number 1, daily list.
1 and 2 have supplementary list. Yes.
Please, Lordship. Lordship, I'm appearing on behalf of respondent number 3, Lordship. Lordship, we just received copy yesterday, Lordship. So, Lordship.
The contempt.
Yes, sir.
What does the instruction say?
Lordship, to file objection, Lordship.
What does it say? You've got instructions, correct? You said.
No, Your Lordship. We just received the copy yesterday, Lordship, of the application.
Only yesterday, why?
They were not appearing in this case, so we stopped.
They appeared last time 10-5, this is after 2 weeks' time to file affidavit. Yes, sir. This one part took place for 2 weeks, but then allowed. Yes.
1 and 2 connected, Your Lordship.
Yes.
Item number 3.
Lordship, I'm praying for.
What happened, Mr. Patha? You just
My lord, since yesterday, my lord, very bad connectivity in Guwahati, my lord.
Because the rain.
I just lost my connection, my lord.
Yes, no, we have posted after some time. We'll take it up again after some time. Yes, what is this? Yes.
My lord, affidavit has not been filed, my lord.
Lordship, I'm praying for some more time, Lordship.
Contempt.
Yes, Lordship.
Contempt, my lord.
The order of the court, has it been complied with or not?
So it has.
No, my lord. As far as the benefits are concerned, my lord, it has not flown, my lord. This is regarding that fifth pay commission judgment, my lord, for ciphers.
Yes. What we have given them 2 weeks further time then.
My lord.
Further 2 week time as per it granted this.
Item number 4.
Lordship, we have filed affidavit, Lordship, in this matter.
Yes.
So, Lordship, their basic contention in their affidavit in opposition is that the gradings which was awarded to me for the period 2019-2020 is not an adverse entry, so it is not required to communicate it, the ACR entries. So The case is all about non-communication of the ACR, and your lordship in various cases also pleased to hold that it is mandatory for the respondent
Gave that case?
Yes, lordship, and it is settled law, and I have annexed one of your decision, lordship, that is
One of my decision, this court's decision, not my decision.
lordship.
Yes.
Your lordship. That is, lordship, annexure F, page 35 of my writ petition, lordship.
Yes.
Lordship, the operative part is at serial number 6. The case on examination is clearly covered by the earlier orders of this court, wherein directions had been issued for redressal of the petitioner's grievances. As submitted, the fact emerges is that the petitioner was never communicated with the adverse entities for the assessment year 2019-2020. And similarly, lordship, your lordship was pleased to direct the respondent authorities to communicate the ACR entities to me in the other cases.
Now,
so this
now
case
in
is
this case where you've been denied promotion?
Yes, your lordship. I have been denied promotion. And this case is also covered by the earlier
Is it correct?
decision.
It's covered?
Yes, your lordship.
With the affidavit?
Their basic condition is at page 5, serial number H, lordship. G and H.
Okay.
That the ACR gradings and recommendation earned by the petitioner taken into consideration by the DPC 2019, that is from the year so and so. And that's serial
They will
number.
dispose it of?
Yes.
In terms of the early orders of this court?
Yes, sir.
If that's the only condition.
Lordship, may kindly take up this matter at the end of the
Let
book.
Dr. Modika come.
All right.
Yes.
Item number 5.
Please, Lordship. I filed my additional affidavit, Your Lordship. Your Lordship, this case, Your Lordship, this member who have resigned, they have resigned prior to the application filed for renewal, Your Lordship.
Then and you withdraw the application with the additional affidavit.
Lordship.
Has no meaning then.
My Lord,
we dismiss
even,
it.
No,
even
Lordship.
the Constitution.
After that, we have appointed a new appointment, new executive member.
Where has it come?
Lordship,
in the
Lordship, it is there, Lordship.
In your additional, where is your additional affidavit?
This page, additional affidavit, we have filed, page 13. Page 13. This is the, after the resignation, we have appointed.
When did you file for renewal?
It is there in my petition, my Lord. That is at page.
My Lord, Annexure 6.
Of the petition?
No, my Lord, Annexure 5, my Lord, page 37. That is a slip when they have applied for the renewal. Annexure 5, page 37.
1 second. So you filed on 28/8/2023 and your people resigned in 22. So how do you see that during the pendency of the renewal application they resigned?
No.
You made a false statement.
Prior to the application, Lordship. They have already.
How did you go and renew when you had no more members? You asked for renewal.
Because the police verification otherwise speaks.
No. See, Mr. P.T. Sommer, you have to come clean. Now you applied for renewal of this association, correct?
Lordship.
Or society, whatever, society. And what happened was that all the members had resigned, you said, between 18/2/23 and 22/23. And the application 28/8/23.
No, not all the members, only 2-3 members, Lordship. Otherwise, the Act also stated that we have
the office bearers.
The very Act of the even Meghalaya Society Decision Act and or the main Act, it says only the society can be registered any 7 members or more. Now we have more than having 7 members.
No. Now you are saying, now when you file for renewal, did you bring notice of the registrar societies also that is going to be constituted and we seek to renew the membership of the society with these new members and that's expired 3 years ago?
No, my lord.
Lordship, I will, to that
We will
effect,
not entertain it.
My lord, this case can be disposed of because the petitioner, if they say that they have already, a governing body has been constituted, let them file afresh with these people who are the actual members.
How can you maintain the petition?
Because at that time, it was a complaint that there was no one present as a governing body.
See the executive members, my lord.
Where? Are they petitioners here?
Yes, they are all.
Are they co-petitioners in this writ petition?
No, my lord, just
They
the
have
president.
given an authorization letter, all the 7 members.
No, my
That
lord.
Annexure 8, my lord.
You can't improve your case.
The petition,
No,
the
this is
petitioner
the main
the
petition
president,
which I
my
have
lord,
enclosed it.
and the secretary, the alleged president and the secretary, my lord.
Let's see. No, we can't get to the bottom of this. Annexure 8.
Lordship.
Yes.
This is the authorization of these members, Lordship. They are the executive members.
Where's the proceedings? Election of the new members.
No, my lord, that is my objection. The affidavit has been filed. He said that they have already considered the governing body, but where is the election? Who are the people?
where's the election?
There is no documents, my
No,
lord.
in the additional affidavit, I have next the meeting, general meeting.
No, my lord, there is a resolution only has been enclosed. Not the members who have actually consented to the election of these
Now
people.
you come annexure 3.
Page 13.
Of your writ petition, page 34.
34.
Are these people still members?
My lord,
They are all
the complainant who has filed the complaint is number 2, number 5, number 6, 7, and 10. These are the people who have written the complaint letter.
Against him?
My lord, yes, that the governing body is not in existence anymore, my lord.
How many members do you have in society? Where's the minutes of the meeting where you elected and where the resolution was passed?
Annexure 3 of the additional affidavit, my lord.
The meeting, the resolution is annexure 3, Lordship.
Of the additional affidavit?
Lordship. Page 13.
Will inflict cost on your petitioner.
And he has a number of criminal cases also, my lord.
Page 13.
30.
113 of the additional affidavit.
Yes. Where's the notice of meeting and where's the signature of members who attend the meeting and there's a list of members. It's a list where it shows that this is part of the meeting.
This is just an extra copy of the resolution, my lord. But they said the meeting was held on 24th February 2023, where the 7 members were office bearer were elected.
Now 24th is election, correct? Of 23. Now this list, annexure 4 is?
This is the, they said this is the list of registered member of all Garwell Archery Association.
My lord, if I may, my lord, in that letter, yes, from 4th March, these are the members, my lord. From 4th March 2023.
Where the members elected your executive committee or your, this is 4th March 23. These are new members?
New members, my lord. Because this election was held on 24th February 2023, as per my friend, my lord. So these people may not be the voters who have actually elected them.
You're a gang of criminals or something?
No, the criminal that involvement, but
that's one thing you admit that.
Lordship, there is no criminal. Only the section 28 of the section 28 of the Meghalaya Registration Act says only the person who is convicted. I was just allegation. There was allegation only that.
M. Sangma.
Yes.
So case registered against Tura PS.
Yes.
So
that I'm admitting.
506. That means all conspiracy, intimidation.
Yes. But I have not been convicted. This is just an allegation against me. Whereas the
I'm not saying you've been convicted. I'm saying, even by the way you've come for this court, you're a person alone who's come. You're trying to be the member of some archery association where you can indulge in criminal activities. That's what you're doing.
No.
In the cover of society.
May I submit, Lordship? Earlier also, they have already renewed when the same case was pending against me.
Yes.
Earlier also they have renewed. They have renewed my register. This is second time, but for the same case they are not allowing it. The ground of impugn rejection, my lord, they have stated that
you implead all the people who file a complaint against you.
No, they have not been bigger party.
Lordship, if that is the case, Lordship, I will just proper instruction.
I'm dismissing this case right away.
No, Lordship,
I'm dismissing it. See, there's a complaint also. With reference that we, the assigned persons, would like to inform me that based on information received, some unknown persons, that is you, has filed for renewal all Garo Hills Archery Association. That all the members of all Garo Hills Association have resigned from respective designation except the president. Therefore, the association stands dissolved. That we have not issued any kind of NOC to any person or clubs. And if any person or clubs has by fake or false documents for renewal, they say, now these documents, they do not substantiate any meeting, any fresh election, any what are the members, nothing. And these old members, they all resigned and said you're trying to...
Because this complaint was not within our knowledge. And in the impugn rejection order, the ground was stated because I was involved in the case, criminal case, not because of that some members have resigned. They have never stated the Annexure 7, that is my main challenge, the impugn order. They have only stated that since there was one of the member was involved in a police case, that is the reason why they have not allowed to renew. If that is the case, that there was in the impugn order, they have never make a mention or even a whisper stated that there was a member of the association have resigned and there was a complaint. They have never stated that.
Yes, they came to learn only later on when he went and applied. No?
If I correct my friend, my lord, his application has not been rejected. It's on abeyance, my lord.
Yes, let's see. We'll ask them to seize the records. In whose possession the records were? We'll instruct SP to seize the records of all your society.
It will be with a member of the association and also maybe with the SP also.
With the SP, you have the records of your society.
Original records.
With the president, I think.
The president or the petitioner. The president is the petitioner here. Must be everything will be with him.
I'll get a proper instruction. Otherwise, my lord, also in the act it says that less than 7 members. Now we are having more than 7 members.
See, we're not talking. You have to show to the court that there is a legally constituted governing body first unto the registered societies. It's been done as per your memorandum article association. You understand?
Lordship.
You'll pick 7 people on the right side of the road and make them sign. You go and register society. Then you're a lawyer. You're not a lay person. See, the members, see your own print. The office bearers shall be elected from among the members present at the annual general meeting. Once every 3 years shall take and hold office from the results of these elections.
Election.
Now, can you show the court that your election was in an annual general meeting of members?
Lordship, on the next stage, Lordship, just given our opportunity, if
we're discussing it.
I will just get a proper instruction. Yes. Otherwise, I will withdraw the petition, my lord.
You already had an opportunity. Court gave you to file additional affidavit.
Lordship, in that case, I may be permitted to withdraw because there may be some defect. It's not intentionally we have done it to mislead the court.
You don't have any papers to show that you reconstituted your office bearers or
because now what I was informed, because they have given only the minute of the extract meeting of the meeting. Maybe there.
What extract? This is just to inform that we had a meeting on 24th. You seen that letter?
Yes, it is there, but there may be proceeding also, my lord, because that to that fact I'm so sorry because but only here, of course, that is only the resolution of the meeting. But what happened prior to the meeting, that of course that is not there, lordship. Only one last chance opportunity. Otherwise, either I can dismiss or I may be permitted to withdraw that.
We listen next week,
lordship.
You satisfy the court or you dismiss it,
lordship.
Can you bring documents to show notice was issued, members were present, elections were held, 7 members were elected, they resolved to seek for renewal? We shall not prepare those documents subsequently, that's all.
No. Not that. That's the reason why I'm asking. Just
and you withdraw it now, you file afresh if you want.
Lordship.
Mr. P. Sangma, after hearing something, please not to withdraw. We're just letting you off easy, otherwise inflicted heavy costs.
Yes. Liberty, with the liberty may be given liberty, sir. With the liberty.
Some length and on objections of the MSR Koni, the government advocate for the respondent, Mr. Petitioner, please be allowed to withdraw the application with liberty to file afresh. If so advise.
Lordship.
Yes.
Second call. Second call. Supplementary list, item number 1.
Yes.
Next, Lordship. Courtroom number 4.
Courtroom number 4.
In that case, my lord, let Dr. Mojika have instructions because ERE duty, Lordship had posed the question, is basically where I am posted out of the battalion. And say, for example, I am posted in the DZAR at Assam Rifles for a temporary period. That is considered to be ERE duty. And
but
deputation
it's not
is where I am.
Correct? Is that a deputation?
My lord. My lord.
Is that a
if
deputation?
I go to other, it is not a deputation.
Okay.
Only when I go to other paramilitary force.
Why can we consider for your? I mean, that is the notion.
My lord, in fact, the Meghalaya High Court judgment has already, my lord, reflected that.
Anyway, I heard Mr. B. Pathak issue notice MSA Pradhan by Dr. Mojika's present behalf of all the respondents. No further note for list after 2 weeks. Instructions affidavit. Yes. Number 2.
Item number 2.
Hello. Item number 2, Lordship was pleased to take up a very similar issue recently. This is again relating to this Fifth Pay Commission benefits and ACP, MSCP benefits of Assam Rifles. Dr. Mojika, my lord, had placed an instruction in the other case. Lordship has a look at Annexer 12, page 101.
Annexer
12.
Page 101. Yes, my lord.
Yes.
Annexer 12, page 101. Some rifles at my lord placed an instruction saying that this is being, because these benefits are being worked out and it is under process and they require certain further time. And therefore, my lord, granting.
Questions also?
Lordship, I'll seek instruction.
The Madam Mojika is not here. Let's post it together with the other case. Same order.
My lord.
This on same date.
My lord.
Okay,
Supplementary 1. Item number 1.
Yes, Mr. Chan.
My please, Lordship. I'll show few annexures with Lordship permission. My Lord's order.
Yes.
Page number 17. My Lord has passed an order on 7.5. Page number 17. And 17. So, my Lord, page 19 would say the operative portion. Lordship directed the government to conduct the election.
Where's the government advocate?
Well, we have given copy to my. Yes.
My lord, I appear in the actual matter in which Lordship is directed to go to have the election.
Yes. And page number 20, my lord, pursuant to my lordship order, the PTO has issued this order on 14 May. In pursuance to letter and such, Karo Hills, pertaining to the conduct of the VEC election whose tenure has already expired, the undersigned will conduct an election as per as and such. In this regard, job card verification to root out the dead, dwelt, multiple Bogus shifted job card holders under the Sagmal VEC will be conducted on the following officers and such. On 14. Now, these teams, 4-member team came to the village and conducted the verifications. And the villagers, including this Kampura, also pointed out, and they recorded. And they say that we will publish the final list of the job cards. Now, we have downloaded, my lord, we'll just indicate page number 21. This is the existing job cards available in the government website.
Before the what is this? Before the verification?
But after the verification, we download this one.
This 14 May verification?
Yes.
So this is a list generated after the verification?
My lord, this is existing verification, existing before verification.
Okay, before verification.
Before verification.
Okay.
Now, I may come later on, my lord. Thereafter, what happened? On 17, they have done the verification, and my lord may come to page number 34. After verification, the authority has issued this notification, this order on 21.
So 406?
Yes.
This, how do you see it, Mr. Changadeso? This is before verification, because the verification
was done on
14
17.
17, sorry.
17, my lord.
And this list is dated 28th.
My lord. This list is an existing list. We printed out yesterday to point out certain, my lord, the names. My lord. Now, before I take lordship attention to that list, I invite my lord to page number 34.
Yes.
After verification, the authority has issued this order. It says, pursuant to letter such 8 May, my lord, I mean, in this regard, the undersigned is pleased to conduct the election of Sagmar VEC on 13 May at Sagmar LP School such. All the candidates and job cards holders are directed to comply with the following terms and conditions during the entire selection process. Now, may I come to point number 3? Therefore, all these aspiring candidates should be only women candidates. And number 6, my lord, candidates' job card holder must produce their original job card at the time of voting. Photocopy or scanned copy will not be allowed. Now, earlier, my lord, here many 25 voters are there, job card holders are there, who participate in the developmental activities also. They receive the wages also. Only, my lord, PTO and the VEC secretary, they did not furnish, supply the original copy of the job cards. Now, if we go by this notification, these people will not be also allowed to participate in the election. Number 1. And number 2, may I come to that list, my lord. Page number 21. May I point out some list, my lord. Out of 406 these job cards are there. Lordship kindly see 49, 55. These are all bogus, the job card double.
How do you know? How will a court know here, sitting here, which is bogus, which is true? This 49?
My lord, 49, 55.
But you said this is an old list.
This is an old list. Now, they came for verification of this, and they remarked the verification team also. And they show that we will publish the...
No. See, if you are saying there's the old list before verification, how can you submit on the basis of this list that this is bogus or that is not true?
And now, my lord, because I refer to this, because of this notification page, my lord may see the page number 34, the last part, my lord. The last part of the page is the election will be in democratic way. Recent database of Sagmal VSC will be used as electoral roll for voting. Now, the existing electoral roll, which I annex, my lord, on that basis still proceeds. And in that, my lord, election will be
recent database of Sagmal VSC.
Yes, will be used as an electoral roll for voting. In that election process should be videographed. Such is the officers designated. Now they are going on the basis of this annexure 3, my lord.
How do you say that?
My lord, this is the existing one.
What happened to the verification?
Therefore, my lord, verification, they are not publishing it. That is a grievance, my lord. Otherwise, I believe I support for the free and fair election. Petition is contested, filing nomination for secretary.
If that happens and you file after elections are over, any grievance.
And even my lord, page number 37.
It's like recalling our own, the court's own order of directing for elections.
Page number 37, lordship, I kindly say. Even the Gangpura has clarified that the final list is not yet published. The last part, as per best of knowledge, the rejected list of some job card holders yet not supplied to the job card holders of this village. Till today, for which they shall not conduct free and fair election. So even Gangpura say that one. And page 38, petition along with others.
Who wrote this one? Who is Anjula Hussain? Who is Noor Hasina Begum? Who are these people?
My lord.
Who are the authors? This is not you.
This is my lordship 37. Lordship is referring to 37.
37, yes. 37
it is written by my lord
headman. Now,
Gangpura.
the next page, this is Who is this?
My lord, the
What
page
people?
38, my lord.
Yeah, one of the petition.
Yes, serial number 3 is a
you.
petitioner, and others are the job card holders who are yet to have even the original job cards, and who are objecting.
They'll root them out when they come for election because they'll have the fresh verification.
Therefore, my lord, they should conduct the election on the basis of fresh verification.
They will do that.
They are not doing that one. That is the problem.
No, they would, when they go to vote, they should show a job card.
My
And
lord,
they'll be
that will be the identity proof, my lord,
And
of
my
the
lord,
voters.
The order says that those who are not having job cards, original copy, they are not allowed to participate. So that is in view of that.
We will not interfere.
Many people will not be able to participate.
We already directed for elections. We can't recall it and stay it. It's set a very bad precedent. One, especially in these areas, once you say any little problem that comes, then they'll rush to the court for staying the VC elections. As it is, it's so contested. Yes, anything to say?
We have filed a missed case. Lordship may issue notice, and the
My lord, let the election be
result of the
controlled.
election would be depend on the outcome of the
Because
election.
if it's interrupted, and my lord has correctly said so also that there will be an identity proof, my lord, of these voters. If they are dual people also, my lord, if a person has already voted, it will not be possible for them.
The instant writ petition has been filed seeking deferment, right?
Yes, ma'am.
Of the elections of the Village Employment Council. Which block is this? Which of which village? Sorry.
Sakmal, my lord. Sakmal
Sakmal VEC. Sakmal VEC.
What?
Sakmal VEC.
Where is that shown?
My lord, page 5 will come.
34, impunity automatic.
Okay. Which is due, which is scheduled to be held on
30th May.
30th May, that's tomorrow.
Yes, tomorrow.
30th May 2024 at 11 a.m. Stop. The complaint of the writ petitioner is that certain job card holders whose names have appeared in the database are bogus, and that certain and other job card holders are not in possession of the original job cards to enable them to cast their votes as per the directions contained in the order dated 8 May. No, which order is this? This 34?
7-5, my lord.
No, order dated?
Well, 21-5.
Where is it shown?
Well, page number 34.
34, yeah, where is 21.5?
Original, my lord, become the 36. Original copies.
Oh, you didn't type the date?
My lord, we kept typing mistake is there, sorry.
If they have given it on top, you should have given it.
Yes.
Top, no? Unknown position. About 21/5/2024 issued by the respondent number, BDO's respondent number?
Respondent number.
Respondent number 4. Number 4. Stop. Next, by Learned Council, Mr. H.R. so praised that in order to ensure free and fair elections with the genuine voters, a verification that has been conducted, the list of job card, a list of job card holders should be limited to the names that have been arrived at on a verification conducted on
17 May.
On 17 May 2024. We therefore praise that until the verified list is published, elections should be kept in abeyance. Stop.
My lord, if I may submit.
Yes.
The petitioner Who is the petitioner, my lord? She has not even enclosed that she is a job card holder, my lord.
No, she's a-
So
she's
how is
a
she to
final
raise an
nomination.
objection, my lord, to
She's
regard to the...
Where's that? Where's the fact?
No, my lord, there is no document placed in the petition. Neither she has made any statement in the petition, my lord. Who is she, my lord? Who is she to ascertain who are these voters and job card holders?
She's a job card holder. She's a job card holder.
That we'll observe. That is her submission.
She's a job card holder.
Yes. Yes, submission. Ms. R. Golni, he appeared for respondents, has at the outset raised objection with regard to the locus of the writ petitioner in preferring the writ petition. Stop. She submits that it has not been revealed or stated writ petition as to whether the writ petitioner is a job card holder for the said VEC or whether he is a candidate, aspiring candidate for the said elections. Stop. She further submits that as the election is being carried out pursuant to orders of this court, so no interference is called for at this stage. Who is called for the stage? Stop. I've heard learned counsel with the parties and peruse the materials as placed up. It is noted that this court, by order dated 7/5/2024, passed in WPC number 38 of 2024, had directed the respondents 3 and 4 to conduct the elections of Sakmal VEC within the period of 6 weeks from the date of the order. Stop. It is further seen that the respondents 3 and 4 thereafter had issued orders on 14 May 2024 for verification of job card holders of job card had for job card verification to root out death, stroke, dual, stroke, multiple, stroke, bogus, stroke, shifted job card holders under Sakmal VEC. And as submitted, the said exercise was completed on 17 May 2024. So, next part, as elections are due to be held tomorrow itself, and as the verification process has been completed, it is expected that the elections be conducted in a free and fair manner as per the verified list and in accordance with law. The prayers, the writ petitions therefore entertained and the same is dismissed. Yes.
Second call, item number 4.
It's the same matter. Is that regarding that non-supply ACR? Where's the petitioner lawyer? This has a habit of disappearing. When the matter has been called out, has been called out in the second call, stop, the lawyer advocate for the petitioner is not present. Stop. Our Dr. N. Mozika has submitted that the instant case is covered by earlier decisions of this court with regard to non-supply of
ACRs.
ACR. Which year is this?
Well, this one is in my affidavit, Melody, lots of kindly, page 5, Melody.
Page 5. Should we note down? No? Non-supply of ACRs. Problem. ACR, stop. The set period is
1920.
For the years 2019-20. Stop. Accordingly, you appeared. record. Accordingly, the matter, accordingly orders, support orders.
Page 37, Lordship, with the same direction came to
Same direction.
Page 37.
Accordingly, of your affidavit.
No, of my report.
Accordingly, as
Para 7 and 8.
As directed by this court
Page
in
37.
WPC number 422 of 2022, White Order 19/5/2023, the incident petitioner, the incident petition is closed.
The year is similar.
Same period is the same. Is closed. Is closed for the direction that the respondents are directed to formally communicate all entries made ACR for the period 2019-2020 within 7 days of presentation of this order before them, to enable the petitioner thereafter to make a representation in a period of 1 month. Next, the representation so presented will thereafter be decided positively in a period of 1 month in accordance with law. And last, next paragraph, further directed that should entries be upgraded in consideration of representation taking into account the petitioner's earlier track record, the respondent authority shall constitute a review DPC for grant of consequential reliefs, if any, on the basis of the above. The entire exercise shall be completed in a period of 5 months from the date of receipt of representation. So, matter accordingly stands closed in this post office.
Hearing item 6.
But may I see? Which
My Lord, I have received an affidavit from my friend. Lordship allowed her to bring on record the inquiry report. But the inquiry report is not annexed in the affidavit. We do not know.
No, it was not for inquiry report, my lord. The petitioner made an allegation that he was not given the notice of the meeting. And we have said that he was called, he refused to come. So those documents have been brought on record. Inquiry report is with Lordship, my lord. The original copy has been submitted on a seal cover, my lord.
Inquiry report, my Lord, may be furnished to us so that we can assist the court.
Let's see that. What does the inquiry report say?
No, they are not furnishing
the
me.
court master, my lord. We have submitted.
You have to inquiry report with you?
No, we don't have the copy. That is.
You didn't take parts. What can the respondents do?
We did not take part. That is the.
Why?
They did not issue notice to me.
Notice was issued to you
No,
as per
it is
the
not.
material.
No, it is not. May I just show in that affidavit itself? I'll just show, my Lord, how the petitioner did not receive.
What are you asking today then?
The copy of the inquiry report so that we can have a peruse the matter and assist the court better. Right or wrong, they have done the inquiry.
My lord, they have not participated. What will be the purpose
What
of...
inquiry report has been generated?
My lord, I have already submitted court master. Lordship has already passed in the last order also that having perused the inquiry report, my lord. And there was an objection raised that he was not called upon for the meeting. So to that effect, affidavit has been filed, my lord.
Oh yes, inquiry
It's a
report.
Mauropat school, my lord. Lordship has called for the inquiry.
Yes. See, Mr. Chareso, even if we give this copy of the report to you, will not allow you to make any objections against it. By virtue of the fact that you voluntarily stayed away.
No. My Lord, if the copy is furnished to us, my Lord, that will...
No, but you voluntarily stayed away from an inquiry.
No, my Lord, the notice was not issued. May I just
See, we can't
page
go
number.
into hair splitting.
My Lord, may kindly see the page number then of her affidavit. The notice, my Lord. The notice issued by the authority.
We'll not reopen an inquiry, Mr. Changri.
But I'm not interested for, my lord, complicating the matter. So, Lordship, to ascertain the
You're
facts.
interested in being a dog in a manger.
That will not. Lordship, kindly see page number 10. Notice dated 22nd April. Now they have addressed to Secretary of the Interim Committee, Head Teacher, Maurapat, Headman of the Maurapat Village, members of the Executive Committee of the Darbar Shillong, Secretary of the Darbar. Now Petitioner strictly assembly is not at all given a copy. Only this notice, my lord. On that basis, they conducted the inquiry.
Now, what about is on page 11?
Page number 11, my lord.
And my lord, 12 is particularly addressed to him, my lord, page 12.
My lord, my lord, the headman is the respondent, and he said that he has delivered to me and I refuse. He's the main person contesting the writ petition. I never received this type of letter from him.
How are we to do to see whether you received it or not, refused it or not?
But my lord, therefore, the notice date page 10, they are supposed to address a copy to me. It is admitted on record. Now they send through WhatsApp from somebody here and there, my lord. That is the problem.
He was refusing to accept calls, my lord.
He didn't accept the lordship.
How can
you
it be?
Video footage of that? Of you going there to...
Yes.
That far we will not go.
Rather, my friends say we have a footage there, never come to the school.
Footage means your footage doesn't count. The person who served notice counts.
Yes. If they can produce the footage also. They did not.
Because his son appeared in the inquiry, lordship.
Oh.
My lord, the question of not knowing the meeting is absolutely incorrect because
his
son has
but it's
participated.
you're only making a case that they were not served formally.
My lord,
At the instance of the writ petitioner, lordship passed an order for inquiry.
See, what about Annexure 5, page 13?
Page 15.
Page 13 of the affidavit.
My lord, this is my letter, my lord. My lord, this I have informed to the director, my lord. May I just read out? Inform you that I am shocked to receive a forwarded message, which is the copy of the letter
on 1st of March, 1st of May. Yes.
Yes. That was sent through WhatsApp number Sunset belonging to Mr. Soon, sub-inspector of the school, on such. On perusal of the said letter appears to have issued by in charge as STO Shillong to conduct the inquiry on 2nd. At the school premises seeking attendance of the addressee of the aforesaid letter, whereas you are directed by the Honorable Court by such to conduct the inquiry. However, the same is not complied with, therefore I request you to comply the same and I am ready to cooperate with the inquiry as directed.
What's not complied with?
My lord, lordship has directed the director to conduct the inquiry, not the sub-inspector.
So you mean to say that since the director was directed and sub-regional officers are going to conduct inquiry, you're not going to cooperate? Some substance.
My contention is two. For one is the lordship directed director to conduct inquiry, and number two, my lord, I was not served copy. I was not served copy for attendance to cooperate to the inquiry. And Mr. Soon is the main person here, who is the chairman of the interim committee.
in his official capacity, my lord.
Where's the letter? Where's that order?
My lord's order.
Which page is it? May I have a point there? If the SDSU is an interested party.
Exactly, my lord.
6th
Therefore, lordship,
March, my lord.
lordship
6th March 2024.
consciously directed the director because of controversy between me and the sub-inspector and the headman.
6 March.
My lord, that is the order lordship is directed to conduct the inquiry.
Around 9, 8 and 9, my lord, will be clear, my lord. Because there is allegation, counter allegation between the headman, writ petitioner, STACO. So lordship has consciously directed the director.
Yes, why the director was directed?
My lord, lordship, in the affidavit, additional affidavit, we have also stated the issue was with regard to language and communication, my lord. If lordship will have the inquiry report also, which we have perused, most of the statements are made in the vernaculars, my lord, in Khasi. So, my lord, our director at this point of time, he's a Marathi, my lord. So it will not be possible for him in his position to actually take a statement of those local people, my lord. So in the interest of the school, my lord, the welfare of the students, this was done, my lord. My lord, we see the entire statements, majority of statements are being made in Khasi, my lord.
That cannot be the ground.
So do one thing.
That cannot be the ground.
You make a statement.
My lord.
You make a statement, what I have to say about the school, that be put together and just let the new report be generated, because everything is given in writing, in the statements. See.
The language barrier cannot be the ground to flout my lordship order. That is not tenable.
If the witnesses are not comfortable, my lord, how will a fair election be conducted?
Taken leave of this court.
Leave of the court, definitely, my lord.
Yeah.
There's a rule of law. They cannot appoint whatever they like. My lord. So my humble prayer, lordship, may give them a month's time to conduct the inquiry and generate the new report.
We are going beyond the prayer of the writ also, my lord.
See, the thing is that you will be allowed to make you give your statement. That'll be considered together with the whatever.
Before the director.
Before the director or before anybody.
We're ready to keep statement for director also, with the supporting documents, if lordship permits me.
Where is it said that language problems?
My lord, in the affidavit I have quoted, my lord. And this affidavit has been filed by the director himself, my lord. My lord, may you kindly have page 5, my lord. That is a continuing of paragraph number 4, my lord. There we have stated with regard to the language, my lord. Page 5 of my additional affidavit, my lord. Continuing of paragraph 6.
Okay. But is it a fact that is the same subdivisional school officer, he has an issue with conducting the inquiry?
My lord, SDEO was not the inquiry officer, my lord. Inspector of schools, my lord. 2 officers, the rank of inspector of schools were the inquiry officers, my lord.
Okay. Objections have been raised to the inquiry report filed by the respondents in the seal cover. Firstly, on the ground that the writ petitioner was never served proper notice. But there was a proper notice to be present for the same. And same, comma, and secondly, that the orders of this court had specifically directed the Director of School Education to conduct the inquiry, whereas the same was done by other officers. Stop. On these 2 grounds, Mr. Ichasari so submits that the inquiry report therefore cannot be accepted by this court. The Director of School Education, respondent number, on behalf of the state respondents, has filed the additional affidavit with regard to the completion of the inquiry and compliance of court orders, and with regard to the direction that he conduct inquiry. It has been explained in the said affidavit that, considering the local scenario and most importantly language barriers, to ensure that inquiries are hampered due to lack of proper communications, the officers of the department in the official capacity who could speak and communicate with locals were vested with the task. Yes. Next paragraph. Yes. Capacity were vested with this task. Stop. Next, with regard to the non-participation of the writ petitioner, this is a new affidavit, correct?
Well, that is our state affidavit.
Yes, it is seen from the same affidavit that effort had been made to serve a notice which, as per Annexure 4 of the affidavit dated 1/5/2024, was refused by the writ petitioner. Though the veracity of this letter is questionable, however, two letters of the writ petitioner dated 1st May 2024 indicates that he was well aware on 1/05/2024 itself that the inquiry was to be conducted on 2/5/2024. But however, has not attended the same, and instead has raised an objection with regard to constitution of the with regard to the where you right now with regard to who was to conduct the inquiry. Further, by another letter on the same date, he is the person conducting inquiry, subdivisional. He conducted inquiry.
My lord.
He conducted inquiries. This G. Maroin.
No, my lord, he did not conduct it. He assigned inspector of schools, my lord, to conduct the inquiry.
Then take it down, no? By another letter of the same date, the petitioner had raised another objection against the sub-divisional school education officer with regard to the inquiry stuff. I made a statement, affidavit that where's by the inspector of schools.
My lord, lordship will have the inquiry report, my lord. The signatories are the inspector of schools, my lord. In the inquiry report, my lord. At the end of the inquiry report, my lord, there are two officers have been signed. Two officers has given the signature, my lord.
Where is the sign? In the front. Okay. No? And these objections with regard to the same inquiry. Which is annexed at annexure 6 to the affidavit stuff. From the facts as spaced above, it is clear that the writ petitioner was well aware about the proposed inquiry and had chosen to stay away by objecting to its constitution, to its conduct, and also on the ground that he was not properly served. Stop. It was open to the writ petitioner at that point of time to appear before the inquiry and to voice his objections. Inasmuch as it can be seen from the inquiry report itself that the same was conducted by one Sri R.R. Lamare, SI of schools, it was conducted by Sri R.R. Lamare and one Sri P. Sun, who are both inspector of schools. Who are all SI of schools.
Sub-inspector.
And who had
Sub-inspector of school.
And who had furnished the report. Stop. Next paragraph. Approval of the report also shows that materials had been submitted by the persons that appeared in the said inquiry. These are submissions. These are that annex.
Well, those are all
yes,
related
for
to
inquiry had been no? The statements had been filed by who had participated in the inquiry, on which basis the inquiry report had been generated. These go back to 21, all these documents and all. Stop. No? Can we allow the writ petitioner to take part post inquiry?
It in fact warrants for fresh inquiry. In fact,
fresh inquiry.
Mr. Marwin also did not come. The officer not authorized by director they came for inspection. Also.
Who?
Mr. Marwin was nominated by the director to conduct the inquiry.
No.
But that is the thing.
He was not deputed. He was to ensure to ensure, to ensure that there was no miscommunication. That's why 2 independent persons came conduct an inquiry. Right. See, that shows fairness. If Mr. Marwin had conducted himself, then it would have been maybe.
Mr. Pisun, my lord. Pisun, who is the respondent number 5 in person who implemented him, he's the one who conducted the inquiry.
Pisun and Ms. Army. I think.
Yes,
I think your writ petitioner is just beating a dead horse. We'll allow you to supplement the. You can file your written statement on the terms of reference as of the inquiry. That'll be considered, and they will just generate a fresh inquiry report.
Let the petitioner give us a
report. Not hear you. No fresh inquiry. This is only no? And recorded by the participants. Yes. Next, for this court, on examining the same, does not deem it fit to order for a de novo inquiry on the grounds as put up by the writ petitioner, inasmuch as the reasons as given on reasons as given. Stop.
Well, just interject.
However, as in the interest of justice and fair play, the writ petitioner is permitted, on the terms of reference of the inquiry committee, to submit his written statements, which will be considered by the inquiry committee, will be incorporated in the inquiry report.
Just inquiry committee may just point out. I'll do that, my lord. Page number 10 of the affidavit.
Yes.
Page number 10 of the affidavit, my lord.
Which affidavit?
Of the
additional affidavit, my lord, which I've recently filed.
Mr. Marwin is the one who is supposed to conduct the inquiry. Lordship, just see the notice. Lordship, can you see page number 10?
Page 10?
Page number 10 of the additional inquiry, additional affidavit.
Yes.
My lord, with reference to the subject cited above, I would like to inform you all, Your Honour, that the undersigned is directed shall conduct an inquiry into the affairs of the Maura persons and sons.
No, this was not conducted by him, but
Mr. Marwin is not the one who conducted inquiry.
Yes.
And
Marwin
Soon
cannot conduct an inquiry because he's an interested party, according to you.
But Mr. Marwin is not an interested party. Mr. Soon is an interested party.
See, we're getting splitting hairs now. Who's Mr. Soon?
Mr. Soon is the, my lord, Lordship, can you see the...
my lord, he is a government official who is part of the interim managing committee, my lord.
He's just interim managing committee.
My lord.
Why he's an interested party? In which way? Have you made allegations against him?
Yes. Therefore, we implement him in person as respondent number 5. And because of that, Lordship has directed the director to conduct inquiry. When Lordship passed that order.
Then we do one thing. I'll pass orders, pour out everything.
Madam.
Without one interruption, you take the order, like it or not. And there's no point wasting court's time. Because the person actually has no right. Actually, will inflict every cause.
My lord, we are going beyond the prayer. They are challenging interim managing committee also.
Second item also,
the
similar.
court, by even pass order in March, was just trying to, settle, calm the waters down. But if this is the way you don't take part on, we'll pass orders, you appeal. Yes.
Item number 9.
Yes.
Same.
Firstly, you misinterpret orders of the court. I remember Mr. Dokrut is responsible for that. He tendered apology. That is the nature of the person.
It was a misunderstanding.
Yes.
Similar item.
Sunshine talk me.
6 and 7 are connected.
Connected with us.
9.
Knowledge.
We'll pass orders. Where's the petitioner?
Kishore, Gautam. But this matter is pending without any reason, my lord. Because now they have to settle, my lord. He's representing MGCC, my lord.
Who? Where's the petitioner?
Is on leave. Last occasion, what Mr. Gautam said, my lord, that he ultimately he has to file a suit, but he only wants to know how much is the amount he is due to get.
How much amount?
Lordship, balance amount yet to be received from NIFT is 1,03,80,000 that we are supposed to receive from NIFT.
You are
And
supposed to
then-
receive?
Yes.
MGCC.
And then from that, we have to make the payment to the contractor.
Mr. Gautam, we're about to dismiss your case.
He is
Kishore Gautam.
Kishore.
Oh, Mr. Kishore. We'll dismiss it.
So this is the.
Yes.
Read may be closed, Lordship, because
We
this
are civil-
prayer is also not.
No,
clear.
what amount is there? Where's the last order? Where's asked for the amount?
It's not reflected in the order.
Is this amount being communicated to him?
Yes, Lordship. I have got a copy.
When was it communicated?
This is the communication, last communication I have received from the MGCC.
Now, have you given this letter to him?
Yes, copy I have given. So if he has any grievance, he can approach civil.
How much
court,
amount is
Lordship.
he claiming?
That is not there in the prayer or of the writ petition also.
Yes, take down. Let's give another chance, let him come. None appears the matter is called out. Stop. Mr. S.E. Upaya submits that whatever grievances the writ petitioner has, alternate remedies available by way of alternate civil court remedies available. Stop. This is a matter after 1 week.
Not tomorrow.
Keep this on record.
I'll inform you.
Yes.
Tomorrow.
Tomorrow?
I'll inform you.
Not tomorrow. Okay, tomorrow. Listen tomorrow. Hi. Where's the fifth pay
Item number
commission?
10.
Where's Mr. Abraham? Who's appearing for the respondent?
KP is leading in this case, Your Lordship.
Where is he?
Just we went to inform him, Your Lordship.
Yes, Mr. Bhattacharya. Yes. We'll close it. No? Bullet points.
My Lord, my apologies. I was under the impression, my Lord, that the final argument will be done today.
You want to make some more final arguments?
So, my Lord, however, my Lord, if that is that way, so I'll file it today only, my Lord.
Today?
My Lord, but before that, my Lord, a few aspects, my Lord, I want to draw to the attention of this Honorable Court, my Lord. Firstly, my Lord, is that, my Lord, what is the right of the petitioners? Lord, whether my lord, they can equate their service with the service of the regular employees, my lord. That is one aspect, my lord. Secondly, my lord, the actions of the government, my lord, whether it is in violation of any rules, my lord. In my respectful submission, it is not, my lord. Because the power, the source is there itself provided in the rules, my lord. Now the government at a certain point realized a certain mistake, and then, my lord, that mistake was corrected. My lord, that mistake was corrected. Now, where is the source of the power, my lord? It is provided in the rules itself. Now, as far as and of course, my lord, the government stand, which is very clear in the affidavit, my lord, with regard to the work charge employees. My lord, that interpretation also, my lord.
That the finance department will give the interpretation.
My lord, which is laid down in the rules, my lord. So my lord, these actions are not in violation violation of any of the rules, my lord. The rule provides there is a stand which was already taken by the finance department, my lord, that work charge employees will only include those employees who have been appointed prior to, my lord, 1997. So, my lord, in my respectful submission, government has acted within its powers, my lord, within its ambit, my lord. There is no violation by the government, my lord. There is no violations of any of the rules and regulations, my lord. Now, even assuming that certain benefits were granted to them earlier, my lord, that does not make it necessary that the same benefits will have to be continued, my lord. If the government realizes at some point that there is a mistake committed, my lord, the same can be withdrawn, my lord. My lord, I will be submitting the bullet points, my lord, and my lord, 2 judgments, if I am allowed to rely, my lord.
Yes.
My lord, this is also, my lord, on pay parity, but my lord, certain observations may be very relevant.
Which judgment is that?
My lord, this is one is, my lord, 2021 19 SCC, my lord, 128. This is Rajesh Praveen Chandra Rajya Guru versus Gujarat Water Supply and Sewerage Board and others, my lord. My lord, this is page 128 onwards. Citation is 2021 19 SCC 128.
But this is regarding autonomous body versus state government.
My lord, but my lord, there are certain observations, my lord, which may be of some relevance, my lord. Page 128.
You're relying on paragraph 22.
My lord, before that also, my lord.
One second.
My lord, if I am allowed to read from my lord, para 4.7, my lord, which is at page 133.
No, but one thing, Mr. Parasai, is this a case of mistakenly being given?
My lord, there is an observation given, my lord.
4.7. Please, yeah, yes.
That by judgment and order dated 15/10/2019, the learned single judge allowed the writ petition and directed the board to grant the benefits of pay scale of rupees so and so to the original writ petitioners, daily rated employees with all consequential benefits upon completion of 10 years of service, and revise their pay scales as per the 5th, 6th and 7th pay commission scales on such basis. The learned single judge also directed to pay the arrears. Feeling aggrieved and dissatisfied with the aforesaid judgment and order passed by the learned single judge, the board preferred letters patent appeals so and so before the division bench of the High Court, by the impugned judgment and order, the division bench of the High Court has allowed the letters of patent appeal and quashed and set aside the judgment and order passed by the learned single judge by holding that the subsequent modified government resolutions dated 1/5/1991 and 1/15/1992 are not adopted by the board. The daily rated employees of the board are not entitled to any benefit following from the modified government resolutions dated 1/5/1991 and 15/2/1992, which as such are not adopted by the board. Now, my lord, subsequently the matter went to the Honorable Supreme Court, my lord. Now the stand
But one thing, again, this is like recommendations from the autonomous body which is not accepted by the autonomous body, correct? And so if wrongly some pay scale was given to them, that then can be corrected. But in this case, if I remember, in the third pay commission and fifth pay commission is identical, the words that the benefits of this will be extended to all work charge employees.
My lord.
Correct.
So, my lord, but
that I think that is what it says.
But my lord,
what are the circumstances which you try to carve an exception that even though those statements are there, but if the finance department has the last word on interpretation of any application that they found that they are not deserving, in view of the fact that after 1997 the work charge employees have been stopped. Tough call. We'll examine.
My lord, if I'm allowed to read, my lord.
Para 22.
Para 9.4, madam.
9.4.
Yes, my lord. But it is submitted that the learned single judge allowed the writ petitions and directed the respondent board to grant the benefits following from the resolutions of 1991 and 92 solely and mainly on the ground of discrimination and violation of Article 14 of the Constitution of India, by observing that the other daily rated employees working with the respondent board are granted the benefit under the resolutions
This is a
of
submission.
My lord, this is a submission, my lord.
Come to finding.
Well, finding is, my lord, para 24 onwards, my lord.
Yes.
In Debashish Mukherjee, while dealing with the concept of equality, it is observed in para 26.
Read para 22 first.
My lord, so far as the submission on behalf of the original writ petitioners, which was accepted by the learned single judge, that a number of other daily rated employees of the board were granted the benefit flowing from the resolutions of 1991 and 1992, not paying similar benefits to the remaining daily rated employees.
So it is in para 20. I think it's clearer.
My lord, in the present case, a concise decision has been taken by the board not to adopt the government resolutions dated 1/5/1991 and 15/2/1992. Even the state government has refused to extend the benefits under the government resolution of 1991 and 1992. The board has taken a conscious decision considering the additional financial burden on the board if the benefits under the government resolutions of 1991 and 1992 are allowed. At the cost of repetition, it is observed that unless and until the board has specifically adopted the government resolutions of 1991 and 1992, like adopting the parent resolution dated 17/10/1988, the daily rated employees of the respondent board shall not be entitled to any benefit flowing from the resolutions of 1991 and 1992. Therefore, the learned single judge erred in directing the board to grant the benefits flowing from the government resolution dated 1991 and 15/2/1992, which is rightly set aside by the division bench of the High Court. Now, my lord, here my...
Now 22? Yes.
22, my lord, so far as the submission on behalf of the original writ petitioners, which was accepted by the learned single judge, that as number of the other daily rated employees of the board were granted the benefits flowing from the resolutions of 1991 and 1992, not paying similar benefits to the remaining daily rated employees would be discriminatory and violative of Article 14 of the Constitution of India is concerned, it is required to be noted that as such, right from the very beginning, it was the case on behalf of the respondent board that the benefits under resolutions so and so were inadvertently and mistakenly given by some of the zonal officers, which subsequently came to be withdrawn. And even the recovery is also sought. As observed and held here and above, the original writ petitioners, daily wage employees of the board are not entitled to the benefits flowing from the government's resolution of 1991 and 1992.
So they say that, so your case is that similarly, since 1997 work charge employment was stopped, so they can't claim parity with the earlier persons.
My lord.
But then in this case, the government taken conscious decision, it is resolution not to extend the benefits. But in this case, it is extended, but by interpretation withheld. Correct?
My lord. Because, my lord, the department or the government realized the fault, my lord, because my lord, and then they relied way back to the earlier notification, my lord, that prior to post 1997 there should be no work charge appointees, my lord. So while relying on that, my lord, the government has also taken a decision that no, these benefits will not apply to the work charge employees who are subsequently appointed, my lord, by the departments. My lord, apart from that, there is also, I'll rely on another judgment, my lord, but before that, my lord, if I'm allowed to place a certain government instruction, my lord, which was issued by the personnel.
You can't be papers like this, Mr. President. They have to be.
My lord, my apologies.
Also.
My apologies, my lord. Because
you can't. It's these have to come by affidavit. You can't.
My lord.
You can't just give.
My lord, my apologies.
Like
these were my apologies, my lord.
Strongly object. Strongly object.
My lord, if required.
Not if required. We can't just prolong the hearing.
My lord.
It'll be like the earlier case, giving a chance to Mr. Changreso's client. No.
So I can give the.
Doesn't only want to,
So, my lord,
eat
here.
the cake and keep it to. He wants to eat the cake and take the bakery too, like that. You can't have that.
I'll give my friends a copy also, my lord. And they can rebut to that also, my lord. So, my lord, this doesn't original.
See, but this was a direction issued only to be violated by all the departments.
But, my lord, the fact remains that the direction is there, my lord.
Option of initiating proceedings as an officer deducting liabilities or avoiding from the salary. So this was filed. This was in 2015. Has any action been taken against those people who still indulge in work charge employment?
My lord, of course, that I'm not aware.
Very wise answer.
So, my lord, these instructions are time and again, my lord, these instructions have been coming from the government, my lord.
You file your bullet points.
My lord, only one last judgment, my lord, if I'm allowed to rely.
Yes, of course.
My lord, this is State of Bihar and others, my lord, versus Devendra Sharma, my lord. This is 2020-15 SCC 466, my lord. My lord, this is page 466 onwards, 466. My lord, this concerns appointments which are neither against sanction post nor in furtherance of advertisement nor any mode of recruitment, my lord.
Where is that? Paragraph?
My lord.
This termination.
Yes, my lord. My lord, there's some observation in para 21, my lord. Because there is a reference to Uma Devi, my lord, in this case. The argument that the employees have legitimate expectations were negated when this court held under so and so, my lord. The doctrine can
But it's definitely you're not sought determination. It's only the. Yes.
But I am just focusing on the rights of the employees.
Yes. Yes. You file a bullet points. You file by today.
My lord, or else 1 or 2 days, my lord, if it is granted.
You only need other authorities, Mr. Nongri. You've given authorities here.
My lord, we have cited case laws. I'll file the compilation of judgments, my lord, by the in the course of the day only.
Yes, sir. Hearings concluded. Our bullet points have been submitted by the petitioners. Mr. Kibarachi, please am allowed to submit points on Tuesday.
My lord.
Just the matters. If I don't list it, you will never submit it.
No, my lord. I'll submit
the
it.
matter on Tuesday of submission by the respondent and authorities.
Yes. Yes, I am agree to that.
No, list and reserve on that day. You don't list it, then.
No,
again,
I'll file it.
It's happened many occasions when I said, okay, fine. Judgment reserve, bullet points to be filed. The bullet points came after 3 weeks. After the court forgotten about the case.
Item 32.
Not your case, someone else's case.
Oblige.
Yes.
This is the contempt petition again. My lord, the brief background of the case is that, my lord, there was an order which was passed by the Deputy Commissioner.
Yes.
That dated 12 November 2022. If my lord will come to page number 11. My lord, this is an order which was passed by the Deputy Commissioner. The order says, relevant persons, my lord, I'll just read out. This is to inform you that in view of a number of programs being planned in the Madan Uringhab, it is at my lord, page number 11.
11, yes.
11, my lord, I'm just reading the relevant persons, my lord, after 16/8/2022, dated.
Yes, okay.
Yeah, this is to inform you that in view of a number of programs being planned in the Madan Uringhab, it is advised that status quo may be maintained as far as usage of the ground is concerned, which includes established procedure of obtaining NOC from the Darbar Snong and permission from this office, subject to all other conditions being met. Now, after this order, my lord, is order is passed by the Deputy Commissioner, the contemptor herein, my lord, she have filed a writ petition bearing WPC number 519 of 2022, and then they have also got an order after filing the writ petitions, my lord. They have got an interim, white dated 16/12/2022. My lord, that order is not part of this. I have, however, mentioned it in my rejoinder. They have got an interim by white order dated 16/12/2022, by which the order of the Deputy Commissioner was stayed. Then thereafter, my lord, an application was filed by the Darbar Snong, who is the petitioner herein, and then on the basis of that applications, the order of stay was vacated, my lord. And thereafter, my lord, the contemptor herein, my lord, has filed a writ appeal, preferred a writ appeal challenging the order of vacating that stay order, my lord.
Yes.
And that in that writ appeal, my lord, the order of the single judge was never set aside. It was never set aside, as well as the order of the Deputy Commissioner also, my lord, was not set aside. What the order of the division bench, my lord, that is enclosed here, that is at page number 8, my lord. page number 8 of the contempt petition, my lord. I'll just read the relevant portions, my lord. We'll read from paragraph 2 onwards, my lord. Indeed, in the judgment and order impugned dated 15th February 2023, the single bench indicated that the matter had to be relegated to a civil suit to be adjudicated by the appropriate forum. However, the limited ground on which the appeal has been preferred is that the previous interim order granted staying an order of the Deputy Commissioner East Khasi Hills dated so and so was vacated by the impugned order. According to the respondent, the larger plot of land where there is a football playground and a basketball court was gifted to the Shillong Municipal Board, and as such public has access to such land. Local boys and girls use it as a playground, and at times permission is granted by the Limekra Dorbarsnong and the Deputy Commissioner for fairs and exhibitions to be held there. The respondent submits that such practice has gone on for years, and as such, till the civil dispute is decided, the Deputy Commissioner required the status quo to be maintained as far as usage of the ground was concerned. The respondent also point out that at the time that the order was passed by the Deputy Commissioner, there was no real civil dispute, and it is only in course of the present proceeding that the appellant herein has sought to assert title over the land in question. In view of the observations in the order impugned, and it being apparent that there is a serious dispute between the appellant on the one hand and the respondent number 4 and 5 on the other as to the title to the relevant land in question, such matter cannot be conveniently addressed in proceedings under Article 226 of the Constitution by way of summary procedure and affidavit in evidence. Accordingly, notwithstanding the limited scope of the present appeal, the writ petition itself, WPC number 519 of 2022, is taken up for consideration and disposed of along with writ appeal number 5 of 2023 by leaving the appellant free to institute a civil suit in respect of the land in question. As to the order of the Deputy Commissioner dated November 12, 2022, status quo will be maintained in the sense that the land will be permitted to be used as a playground, and in very exceptional cases, subject to the previous permissions of the Deputy Commissioner, the odd fare may be allowed, but this should not exceed more than two a year till such time the dispute as to the title is resolved by the appropriate forum. However, if the appellant does not institute an appropriate suit canvassing title in respect of the land in question within a period of 3 months from date, the effect of the order passed by the Deputy Commissioner on 12th November 2022 will remain undiluted. Now, as the learned single judge held that the matter involves disputed question of fact, and therefore it should be decided by the civil court. Similarly, my lord, even the division bench had the similar view and directed the parties to approach the civil court and did not set aside the order of the learned single judge as well as, my lord, the order passed by the Deputy Commissioner. As a consequence, in terms of the order of the Deputy Commissioner, the normal procedure which is to be followed is
one thing, they instituted a suit within 3 months.
They have instituted the suit, my lord, and thereafter civil suit is pending, my lord, before the learned trial court.
Which
now,
court is it pending?
District Council Court, my lord.
Why District Council Court?
Yes, my lord, the Shillong Municipal Board was not made a party. That has been taken up before the...
If there's a ground is recorded here, according to Principal Larger Plot of Lands, which is granted under Deputy so-and-so, where that is given to... It should have been made them even a pro forma also.
Right. They were not made a party in that...
that means that suit, that plaintiff be returned.
Should be. We have already brought it on record.
But if you want a full adjudication, I think Mr. Kanta would have been well advised actually to whatever parties that might have claim should have arrayed them as parties, whoever's...
That's a different issue or subject matter altogether.
I'm just asking
so
what
far
suit,
this matter is
suit.
concerned, we have to look into it whether there is any contempt committed by
I'm
the...
just making a general observation. Contempt, we will see. We know what is contempt jurisdiction. Yes.
Now, what has happened, my lord? The order of the writ, order in the writ appeal, my lord.
Now, what do you see has been violated?
Now, my lord, what has happened is, my lord may kindly see page number 12.
We've seen division bench order. Okay, fine.
Yes, my lord may kindly see.
Appropriate suit canvassing this within 3 months. They've instituted.
Yes. In spite of
what
that,
orders have been passed in civil suit? That's why I'm asking for civil suit. If orders have been passed, that means that effect of the order received diluted. If orders have been passed in civil suit.
Yes, we have.
that suit is.
They have obtained orders or not?
There are orders, my lord, which has been passed, and that has been handled by Sir Themis, different counsel, my lord. My lord, my only contention here is, my lord, the learned division bench never allowed the petitioner with any rights. They had to go before the civil court, prove their rights, and thereafter, my lord, they can claim something. Now, as far as the order of the division bench, my lord, it did not set aside the order of the deputy commissioner, which said the normal procedure to be followed. That is the order from the permissions from the Darbarsnong and the permission from the deputy commissioner's office to hold any program. Now, what has happened is, page number 12, my lord, in spite of the order passed by the learned division bench, dated 9/6/2023, the contender, my lord, has issued NOC to different persons, my lord. This is one of the NOCs which has been issued by the contender. And in the affidavit which has been filed,
See, just go back to the last part of the division bench order.
my lord.
See, it says that this order is at page 8, correct?
Yes.
Yes, it says,
R6.
however, the applicant does not institute appropriate suit when the date effect order will remain undiluted.
If they do not file the civil suit, my lord, they have filed the civil
have
suit.
filed.
If they would not have filed, means order of the deputy commissioner will be final.
Yes.
Yes, but here the court has said that the order of the deputy commissioner status quo, in that regard, status quo to be maintained, my lord, in the first paragraph line only, paragraph 6.
Okay, yes.
Will say, it says the order of the deputy commissioner dated so and so, status quo will be maintained in the sense that the land will be permitted to be used as playground. My lord, that order was never set aside, my lord. Now, in spite of that fact, my lord, the contender has issued a no objection certificate, my lord, as regard to the.
What did he say about the that NOC?
Yes, my lord, may kindly see the affidavit which has been filed by the contender, my lord. That is paragraph 4, my lord. Paragraph 4.
Yes. Yes.
In the paragraph 4 of the affidavit which they filed, my lord, it says that as regard to the statement made in paragraph 3 of the petition, it is admitted that the humble deponent had issued the NOC in question in as much as acting on the submissions made on her behalf, this honorable court, and in penultimate paragraph 6, paragraph number 6 of the judgment and order dated so and so, passed in writ appeal number so and so, had permitted appellant to allow holding of not more than 2 fairs in a year as an interim relief pending resolutions of dispute by the appropriate forum. This was a wrong statement which has been made, my lord. Misleading statement. Never allowed, my lord.
Yes.
So, my lord, when the order was very clear, and when the division bench did not interfere with the order of the single judge, as well.
Order of single judge.
Order of the single judge was to by which the interim order was vacated, my lord.
And the order was restricted by division bench.
Right.
Yes.
And that order was
in the
challenged.
sense that order of the deputy commissioner.
Order of the deputy commissioner
was
is that.
restricted by this. Read this order again. See, it says that as to the order of deputy commissioner dated November so and so, states could be maintained in the sense that the land be permitted to be used as playground. In a very exceptional case, such provision, the odd fair may be allowed. But it should not exceed more than 2 a year. So, is it the deputy commissioner to give permission, or is it will remain as before that the NOC Darbar and deputy commissioner? That you have to make clear.
Yes, my lord.
In interpreting this para 6, if that is the case, then for them give NOC there in contempt.
Yes.
As the order of the commissioner dated November 12, 2022, status quo will be maintained in the sense that the land will be permitted to be used as a playground, fine. A very exceptional case, subject to previous permission of the commissioner, the odd fair may be allowed.
Because the order was not set aside, order of the deputy commissioner. So the procedure which was followed, normal procedure, has to be followed, my lord.
Yes, Mr. Kanta. Under what authority did you issue the NOC? As
No.
your
Authority is
your
because
explanation-
I'm the title holder.
You know the title holder. This has not been proven till the civil court proves it. This is, you can't make the submission also. Paragraph 4, you sent that, whatever you said here, on a made as acting on submission made on her behalf with this honorable court.
Pardon your?
Acting on, read that paragraph 4, what you've written in your reply.
Lordship, can I draw your
No,
lordship?
no, please, I just want to understand this paragraph 4. That regards, it means that much as acting on a submission, made whose submission? Made on her behalf, on your submission. That NOC can be granted.
Lordship, can I draw your lordship attention to the petition filed by the...
Yes, of course, just trying to understand.
I will slowly draw your lordship's attention.
Yes.
First and foremost, this Annexure 2, the focal subject of dispute, 12th November 2022. What does 12th November 2022 speaks? To the Chairman Ramashnong Lamkra so-and-so, in inviting a reference to your letter number so-and-so, so-and-so. This is to inform you that in view of a number of programs being planned in the Madan Uringheb number so-and-so, so-and-so, it is advised that status quo may be maintained as far as usage of the ground is concerned. So far that part is concerned, I have no dispute, Your Lordship. Which include established procedure of obtaining NOC from the Darbar and permission from this office subject to all conditions being met. Now, the Darbar will be responsible for dealing with any claims, legal dispute arising in the use of said land, if any, as indicated in the letter dated 16 August 2022. Now, consequent to this letter, 12 November 2022,
Yes.
we have filed a writ petition before this Honorable Court, and that writ petition came to be closed in WA number 5 of 2023. Now
In this order that's here.
Now I draw your Lordship's attention that paragraph 6, let me just again to reiterate, Your Lordship, what my colleague has already said.
Mr. Kanta, sorry, do you have the orders passed in the first order and second order? The court doesn't have memory of, until we call the records. The orders passed in the prayer and the order passed in the Ranto single bench.
Paragraph 5 of page 10 of the petition, Your Lordship. Accordingly, notwithstanding the limited scope of the present appeal, the writ petition itself, WPC number so-and-so, is taken up for consideration and disposed of along
Or
with
disposed of by the appeal itself.
It's merged. It just merged there, Your Lordship. It is not that a separate order is still surviving. It merged with WA number 5 of 2023. By leaving the appellant free to institute a civil suit in respect of the land in question. As to the order of the Deputy Commissioner dated November 12, 2022, status quo will be maintained in the sense that the land will be permitted to be used as a playground, and in the very exceptional case, subject to the previous permission of the Deputy Commissioner, the odd fare may be allowed, but this should not exceed more than 2 a year, till such time that the dispute as to title is resolved by the appropriate forum. However, we have to read again and again, Your Lordship. However, if the appellant does not institute appropriate suit canvassing title in respect of the land in question within a period of 3 months from date, the effect of the order passed by the Deputy Commissioner on November 12th also will remain undiluted, meaning that the moment the suit is filed, this November 12th order of the Deputy Commissioner goes, Your Lordship.
No, you have to have other orders. Mr. Kanta is like this. Till such time a suit is instituted and effective orders are passed. Now this court's asking what happened if you file a suit, what orders were passed in a suit?
Yes, Your Lordship, there
What
are
were
orders.
passed?
My
You
colleague
please
is...
produce the orders. Let us see what orders were passed by the civil suit. Because you have to go by, it's a civil dispute. See, a civil dispute in writ jurisdiction, we're not going to go into disputed facts.
According to us, there is no contempt whatsoever, Your Lordship.
No.
And the order passed herein
Please
after.
listen, don't get agitated. What this court tries to say is contempt jurisdiction, and by extension, writ jurisdiction. If the order says state to be stated that if the appellants of the institute, it is a open-ended order. It's contingent upon you filing a suit. So court will examine whether any orders have been passed by the civil court, vesting you with any authority to issue any NOC. That's all.
Your Lordship, I'd like to draw your Lordship's attention to order dated 9 November 2023.
Yes.
Actually, it was passed in Miss case number so and so. And I just want to read the.
What stage is the suit now? It was very difficult to decide contempt if it's the parallel proceeding anyway, which is contingent.
That's my case, Your Lordship.
That's the thing, Mr. Khan. Very difficult.
That's my case. Now I just draw your Lordship's attention to that to page 2 of this order dated 9/11 at para 1. The instant suit is posted for orders on ad interim injunction as prayed by the plaintiff petitioner, that is we, to secure the prima facie title ownership possession of plaintiff over the suit land. At para 2, the defendant opposite party was afforded an opportunity to file his show cause against the prayer of the plaintiff petitioner. However, the defendant opposite party did not file the show cause, and the matter was heard on 13/10/2023 for ad interim injunction. Now, I'll not waste the time of the Honourable Court. I'll draw your Honourable Court to para 22, Your Lordship, of the order, just to save time of the Court, Your Lordship. Para 22, Your Lordship. Furthermore, this is a matter which was heard extensively by giving opportunity on both sides. Furthermore, the suit land being a playground, it's page 39 of that judgment.
Internal.
It's a
long order.
It's a very long order, but I'll come to just a relevant paragraph, Your Lordship. Page 39, Your Lordship, internal page, at para 22. Furthermore, the suit land being a playground is not in the actual possession of either party. However, both parties claim to have constructive possession of the suit property, whereby both parties grant permission for usage of the ground by any third person. It is of paramount importance to distinguish as to who is in actual possession of the suit property. In the instant suit, none of the parties are in actual possession of the suit land. Therefore, no probable inference can be drawn to establish possession of either party. Para 23 is the most vital para, Your Lordship. Based on the observation made herein above, no ad interim injunction can be granted in favour of the plaintiff petitioner. However, considering the fact that the Honourable High Court of Meghalaya in WA number 5 of 2023 had directed both parties to maintain status quo, and the odd fare not exceeding 2 in a year may be allowed, the same in the opinion of this court should be with a consideration for the plaintiff petitioner while granting such permission till disposal of the suit. Now that is the most operative part, Your Lordship. It should be with the consideration of the plaintiff petitioner, Your Lordship. Now I come to another order, Your Lordship. That is flag 2.
Your affidavit was filed when, Mr. Kinta? Your affidavit was filed on 12/10/23.
Now I come to at paragraph at flag 2, Your Lordship.
Oh no, it's understandable then, because this contempt was filed before these orders were passed.
My Lord.
So in view of these later orders, Mr. Sinkon, since the civil court is seized, whatever additional orders you might get, you have to obtain them from there.
Lordship.
Because see, the thing is that in contempt very difficult to discern because the order is open-ended and the civil court sees the matter. And if this order is there, have you what happened to injunction, final injunction now? It's been decided.
Your Lordship, it was disposed of by this order dated 9/11. Entire thing was disposed of.
9/11?
Huh? No.
Civil suit.
Not the suit. What I'm saying is the interim injunction.
Injunction
There's just some directions given.
Your Lordship.
So, how did it dispose of the entire thing?
Your Lordship, let me just. Thereafter, a show cause was filed by the. Consequent.
After the
9/11.
Disposed of.
No. Actually, after 9/11, the petitioner herein as defendant had filed a show cause.
Yes.
And in the meantime, there was some violation by some third parties who went to conduct puja, etc. in that land. And they also don't know, and we also don't know, and we file a petition before the civil court. Then at flag 2,
Yes.
at flag 2, Your Lordship, there is an order for the police to
Now what happened to this after this order dated?
Then after, Your Lordship, I just, not to waste the time to quote, I draw Your Lordship attention to order dated 26 March.
I've seen that also.
Yes, especially.
What's happened to the matter now? See,
now they have filed a petition for dismissal of the suit for lack of cause of action and for etc., fee, etc. It's pending there, Your Lordship.
we'll close the contempt, Mr. Sinkan. It's become it's called hydra-headed to avoid at many levels. Yes. The contempt is too limited. No, contempt for unless there is a willful and direct violation of the orders. Now, these orders were obtained because this writ appeal order is contingent upon them issuing a suit. Correct.
My lord.
That is the thing.
But that order has come later on, my lord. My contempt was filed earlier. And if my lord will see the rejoinder affidavit which I have filed, my lord, there is a...
My colleague here did not disclose.
We will not go split hairs. There's no point in fact, this matter should be amicably resolved. Because the people are suffering are the people.
We made that offer many times, but they don't want to come.
It's not that. It's
we wanted to...
Where?
My rejoinder affidavit, my lord, which I have filed. If my lord will come to page number 11.
If you think they can file, you can file a fresh proceeding. No one's stopping you. But in contempt.
Page number 11, my lord, last portions, my lord, they are giving misleading statement before the media as well, my lord. That is a type copy. Last paragraph, my lord.
That's a different issue altogether. There's a second writ petition also filed, Your Lordship, by them. First filed by us, then they filed a second, that also was closed in writ appeal.
This is your statement before the press. Mr. Kanta.
Where's that? What are you reading?
Page number 9.
Page 10 na kaliang nong esay an ba we can tell on kaday whatever this you.
Yes, it's informed that there is a matter pending before the court.
Such direction, my lord, was given by the High Court.
Yeah, Mr. Kanta, senior counsel, you can't make this kind of statements.
They started first to give a press statement.
Starting first, you're senior counsel.
We retorted.
I mean, making the statements on the paper, that's...
Yeah, that's a different course of action, Your Lordship. We wanted to pursue.
Good case at all. You can't use... see, in contempt, it's very limited. Court will not take action. But then, if this is brought notice again, these kind of unseemly things will be compelled to initiate some action because it's not in good taste. The matter you fight it in the courts in a proper manner, both for the parties, even for your party also.
They also made statement, that's why we made.
Yes, we'll close it, but there won't be any, let the matters simmer down. Yes, contempt case 25, like, this application has been filed alleging contempt of the order dated
9/6/2023.
Order dated 9/6/2022.
2023.
9/6/2023.
Passed in WA number 5 of 2023.
Oh, sorry. This one has been filed alleging contempt of the order dated 9/6/2023, passed in WA number 5 2023. Stop. Next, by those submissions have been made that the respondent Contempt has violated the orders of the court. The same it is seen, though there might be materials that point in that direction, is already seized by the civil court presently. Stop. As such, any further violations or infractions would be better addressed by the court where the matter is pending. Stop. Without adjudicating on the alleged disputes, contempt stands closed.
Much obliged.
Obliging.
You're not expressing anything, because you have recourse to whatever remedy.
Much obliged and good day, Lordship.